Thank you, Dr. Ranjit, Dr. Ankit, and all the dignitaries across the globe. I am very much thrilled to discuss and to learn many things from such a gathering. And I always feel honored to participate in such academic endeavor. So, just coming to the discussion, just please, just go ahead. Yeah. A slide ahead, please. Yeah, a slide ahead. Yeah. So before I introduce the subject, let me just give you a kind of glimpse why forensic science is required. And this is the figure actually of Indian scenario, particularly the rape incident in the country. Can you just click once more? Yeah, so if you see the charge sheet filed by the police in these cases of rape incidents, police file charge sheet in nearly 90 or 85 to 90% cases, broadly speaking. But if you go to conviction, another click, please. If you go to conviction rate, then it is nearly 30%. And here is the catch. Catch point here is that generally the investigation in most of the country, and I have occasion to discuss all these points sometime in various developed countries also. Last year, as a Fulbright fellow, I happened to visit many academic institute, many police organization, judiciary and all. So the scenario may be a little bit different, but still there is a wide need to have more usage of forensic science. Here the catch is that police feel that we completed the investigation, we have done our job, and we file charge sheet in nearly 90% cases. That means that the case is established on behalf of the police. But when trial commences, it is found in that court proceedings that the evidence quality is not sufficient to convict a person. That means there is a gap. And this gap, how to bridge, is a very major challenge for the entire, governance, entire society. So in general, what we do in our investigation across the globe, that eyewitness we consider is a primary witness. But everybody knows that oral testimony has so many challenges. People may have the personal vendetta. There may be some concocted witnesses. There may be some memory issues also. Sometimes you may perceive differently. So oral testimony per se is not adequate, and there are a sufficient reason to believe that miscarriage of justice may happen. So this answer, bridging the gap of charge sheet in nearly 90%, conviction rate 30%, this gap of 60% is a major concern for us. How to deal with this such situation? Next, please. Yeah, 2 times more. So the scenario remains in child sexual abuse also. To those who are from other countries, let me tell you that we have introduced in India the POCSO Act, Prevention of Offense Against Child Sexual Abuse. So this act was introduced in 2012. And here also, my dear colleagues and friends, that police file charge sheet in nearly 90% cases and conviction rate is 30-35%. By and large, this challenge remains the same. Many countries like US, although we find conviction rate quite high in many cases, but if you go to little deep, you will find that many cases of conviction are either for confession or by guilty plea. That means in either case, the actual appreciation of evidence is not there. And I had occasion to meet more than 12 people who were on death row last year, and they were being exonerated under Innocence Project and other such NGOs efforts and all. I could understood that despite they are innocent, they are being convicted. So merely considering that conviction rate is the yardstick to measure the good quality of judicial governance may not be correct. We have to be very objective. We have to be very critical. And here lies the role of forensic science, because forensic evidence, the expert opinion is neutral. They do not take any side. The expert opinion may be used as inculpatory evidence to prove guilt. Simultaneously, the expert opinion as an evidence may be used for as exculpatory evidence to prove innocence. And if you remember the DNA, the advent of DNA by Professor Alex Jeffrey, he first in 1986, this technology when it was introduced, many of you may be knowing, but few may be surprised that Richard Buckland, who was accused of two rape and murders, where this technology was invented first in London, he was exonerated by DNA. So exoneration is also a very important part of our criminal justice system. That means we should not think only for conviction. We should think about the justice, the fairness in justice, the correctness in justice. And I always say that judges deliver judgments, and it is once good luck if you get justice. And I qualify this observation that if every judgment of a judge, whether it is Supreme Court or any court for that matter, if every judgment is sine qua non or equivalent to justice, then there is no need of the doctrine of appeals. That means if you have kept a provision of appeal in higher courts, that means inherently you have believed, or there is a possibility that in a judgment there are chances of miscarriage of justice. So my dear friend, we have to bridge this gap, and this gap bridging can be done by corroboration by neutral evidence, and forensic science is the best tool if we have done with the honesty, with proper procedure. We will take up how to proceed those things and what are the challenges. Yes, please, next slide. Yeah. So friends, if we see during investigation, the major role of investigation is basically detecting a human being, either as a victim or as an accused. On victim side, many times we as police officer find that there may be a small child, maybe neonatal, may be impaired, may not be able to give his own identification. So victim may be dead person, may not be identified, it may be bone, it may be body remains, and so on and so forth. So on the side of victim, human identification becomes very critical and very important to identify that this is the person who get victimized. On other side, even if a person is named with the accusation, it is named at accusation, X person is named by the victim, even then the entire proceeding of criminal investigation hinges upon correct human identification. The same role is being conducted even by the judges. The entire criminal proceeding lies or is aimed to find the correct human being who is responsible for committing crime. And for that purpose, we as an evidence utilize morphological features, photography, sketch, and so many other things. And of course, DNA is the latest technology, not latest, now it was invented in 1986. So nearly now it is going to be 40 years plus. So human identification is still, DNA remains one of the best technology available to everyone. Next, please. As I already mentioned, although this is for our Indian Evidence Act, normally to prove or disprove a fact across the globe, there is no limit how many witnesses the prosecution produce. So you can establish a fact even by a single witness or maybe more, right? But as I mentioned, that oral testimony, including the eyewitness, which is considered the primary witness, right? They have a lot of challenges, as I mentioned. They may be planted, they may be interested, there may be memory fade, there may be hostility, and so on and so forth. So we need a neutral, tool for the purpose of corroboration. And my dear friends, corroboration is a very, very important doctrine to bridge the gaps, to complete the chain of events. Corroboration is very, very essential part. And forensic tool, forensic evidence, expert opinion is the best possible tool if it has been conducted properly, without any manipulation, without any fraud. Because I will touch upon little bit as challenge the forensic frauds also to some extent, but that is very, very important. Next, please. So let us understand, although it will be merely repetition, because everybody sitting here is a forensic expert, but still it is my duty to just bring law with forensic science. And I believe, and the institute which they have referred, I am the director, it is the upcoming institute. We are trying actually to bridge the gap between forensic science and law. My dear friends, if you are using forensic science in the court of law, until unless forensic experts know the basics of law, they cannot withstand the language and dynamics of the court proceedings. So in this institute, we are trying to bridge this gap. We will be giving some kind of understanding, some kind of transfer of knowledge to our students of law. And we are developing moot court also in forensic divisions, so that there should be intermix of law student as well as forensic student. Likewise, the legal studies. And I have designed a course for our students since last 5 years in many institutes, that law and forensic justice. So I suggest, as a practitioner of police as well as an academician of forensic science and law, that please think that forensic science candidates or students and even the experts must have some basic understanding of law. Likewise, the legal expert must have proper understanding of forensic science as an evidence, expert opinion. Merely just reading few lines or few pages doesn't give them a proper understanding, and that is why they generally go for expert opinion. But I totally believe that this is a requirement. So what is forensic science? Forensic science, when it is used in criminal side, it is called sometimes criminal justice. And this science is basically the baseline of scientific investigation. See, friends, forensic science is not a pure science. It is a hybrid. It is an admixture. It is admixture of social science subjects like anthropology, like art, like language, your forensic or your foreign law, and so on and so forth. Of course, science streams are there: biology, physics, chemistry, and so on and so forth. The entire purpose of this exercise of forensic expert opinion is to enhance probity. And my dear friends, probity is the crux of evidence to be produced in the court of law, whether it is a civil matter or criminal matter. And I always say that law, if you want to define, it has three appendages. First is the act or omission, whatever you do, it should emanate justice. The second tenet of law is basically reasonability, the logic. And forensic science, expert opinion brings logic, what the fact is to be stated. So this reasonability of the fact, so that based on that reasonability, court come to conclusion that yes, this is a true fact. And as I always say, that entire justice system is dependent on three words. One is justice, another one is truth, and then evidence. Generally, you can reach to the justice through truth behind a fact. But justice and truth, my dear friends, they are intangible. It is the evidence actually which give the tangibility to the entire proceeding. So here comes the role of forensics. So if you have a neutral forensic evidence, then you can bring the proper justice, which have very limited scope of any miscarriage. Then, as I said, the entire proceeding, what we are discussing is basically bringing perfectness in the judicial system, the justice system. Next, please. What is an expert opinion? I don't want to explain section 45 because there are many other countries experts also. But in our Indian, procedural law, section 45 define, and it doesn't define actually, it indicates who is an expert. And it says that when the court has to form an opinion upon a point of foreign law, so it is not scientific subject. After foreign law, it is science, it is art or identification of human or handwriting or fingerprint. Then the opinion upon that point of person. So the point here is, generally I will come to that point because that is very crucial. Many times our expert could not define in court that how you can establish that you are an expert. And many times they get stuck. And the major role of the defense lawyer is to create confusion in the mind of the defense, in the mind of the judge. So you have to be very clear that how can you say that I am an expert in the eyes of the law. So this is very beautifully defined in our one of very important judgment of the Supreme Court, and that case law is State of Himachal Pradesh versus Jalal. Those who want to read it, it's a very lucidly written, I think 5-6 pages judgment, and it is free of cost available. If you just write it on Google and just write Indian Kanun, you can download it free of cost. The legal question is, this case was, this person actually, I will just give you in 2-3 minutes the background. Basically, in the state of Himachal Pradesh, which is a hill terrain, it is a very renowned state to develop or to grow apples. In 1983-84, there was some disease in the apple crop, and the farmers suffered a lot. Government thought to give compensation for that loss. So there was the need to determine that how much crop a particular field of a farmer was having. So this gentleman at that time, Mr. Pawar, he was a district horticulture officer. He was assigned the task that please assess how much crop a farmer was having in that area. So after this exercise was conducted, there were allegations that there were bungling actually in determination, and many people who were not having actual that much crop have been given or been assigned more compensation than it was actually must be. So this case came. So the legal question was whether this gentleman was an expert in the eyes of the section 45 of the Indian Evidence Act. So this actually says, and this is the important point I want to bring, that who is an expert. So these three things one should remember. First is he or she should be especially skilled. How to determine especially skilled? There are two values. One is his education. Generally, if you are being recruited as an expert in any forensic laboratory, court believe that that education is essential, and if you prove that I have that education, they tend to accept. The another one is very important, is the experience. This experience is very critical. So if you do not have that experience, that how many cases have you done, the another point, the procedure adopted for reaching or to conduct that test, whether that procedure was accredited. And of course, you must be knowing the two basic standard tests. They were Frye test in 1923, which was introduced through polygraph. And the second one was the Dover test, introduced in US in 1993. So this procedure and the laboratory must be accredited. So this is the second point. If this point is not being proved by an expert, then whatever report you give, it is valid. The third point is basis of your conclusion. Generally, we write and we believe that court will accept this. No, gentlemen, you have to share the metadata. That means how you reach to the conclusion. That is sometimes it is called hand notes also. So whenever you go to the court, you always be well prepared about the procedure, about accreditability. Then the metadata, you should carry that. You cannot just jump to the conclusion. You have to prove that. Otherwise, court will disbelieve and your report make no sense in the court of law. The next one. So this is, I have already mentioned. Remember one thing, very important point. An expert is not a witness of fact. I must explain this, but it is little time. I am short with the time. The expert opinion must be intangible. It must be convincing, and it must be tested. This is very important. If you have more interest to read, this is another important judgment of Indian court. That was also the Supreme Court of India. Haji 𝐬𝐤𝐭, State of West Bengal. This is another important judgment. And let me tell you one thing, because many of you are experts. Until unless you understand the law through court cases, this is the best way to understand the law. Please make habit of your subject. If you are dealing with DNA and you may be in X country or Y country, you must get some 4, 5, 6 good judgments, because there you find that how your expert report has been evaluated, how it was criticized by the defense lawyer, how your prosecutor have saved your argument or your decision. That will give you entirety of what you have done. Otherwise, if you send just and forget about it, then you are not going to serve the purpose. Because until unless you see the end product, and end product is the judgment, my dear friends. Don't miss this chance if you really want to contribute in the judicial and the criminal justice system. Next, please. Yeah, this is very important point. I want to give just 2 minutes time, although it needs little more explanation. You see, you must understand how an evidence, whether it is oral or any kind of evidence, including your forensic science expert opinion. The admissibility is the crux. How an evidence get accepted in the court. That is called admissibility. It has 2 appendages. Very important. One is reliability and another is validity. Normally, most of our forensic science tests, not all, I will come to that. Most of our forensic science tests, generally, they qualify the first test, that is reliability. What is that? That is factual accuracy. It can be reproduced. Like if you are saying that H2 plus O2 makes H2 with given temperature, pressure, and volume, it can be produced anywhere in the world. By a child, by the elder, in the day, in the night, whatever. So the technique what you are using will be admissible when it is reproducible. It is replicable. It gives you consistent results. Then only it will be trustworthy. But the second criteria for admissibility is little difficult. Rather than going into detail, what is foundational validity and all this needs actually little more detailed description, and neither you have time nor, because I have given limited time, so I don't want to get into the deep down into that. But I will give you just example, and then you can well pick up what I want to say. See, for example, everybody of us know that deception detection technique, whether it is narco-analysis, maybe polygraph, maybe brain mapping, and many more techniques which have been introduced in the recent past. Why they are not evidence per se across the globe? Why? Because they do not qualify the test of validity. What it is? Say, let's examine the polygraph. What are the parameters based on the metadata behind the report? They generally have some physiological changes in the body, normal. Like if suppose some wrong stimulus or false stimulus you are just trying to give, or something like, suppose if you have committed murder or a person is examined for murder. So if you ask some question, it is believed through this technology that your physiological, biological changes will occur, right? Like say perspiration, your dilation of your pupil, eye, then your heartbeat, pulse rate, and many more such 7, 8 standards they generally occur. But if you test in the ground, suppose if a person who is a hardened criminal, his BP will not rise even if he has killed 10 persons. But if a person who never have interacted with police, even if a police just stop him on road, he will start perspiration. His heartbeat will rise. and those parameters which you are measuring, they get disturbed. So this technique are not standardized. They cannot be reproduced the same result. They have no replicability. So only thing with these technology, they give you a ray of hope in the blind cases. If you want to screen, say there are 50, 60, 70 people. Out of them, you can utilize them. Sometime it may give you a kind of some result based on which you can move forward. And if you get some credible evidence, then only it may be helpful. Otherwise, by just saying that it is trustworthy, it is non-trustworthy, that type of report make no sense and has no value for the evidence. Next, please. I think I have already told about DNA. The time is less, so we just move ahead. We are aware about the DNA technology and all, and I think it becomes a wonder science. Next, please. Next. Yes, we know this. Yeah. Next, please. So I think this is the last slide. I don't want to take much of time because so there are major concerns. As I told that I want to make some challenges also to the forum. At the sample level, there are a lot of contamination. Although in many countries people are aware, but country like, especially like developing countries, people get excited when they come to know any crime or something, and they generally muddle with the crime scene. So crime scene management becomes very, very important. And our institution is basically trying to develop some technology with the management, the crime scene management, using technology like blockchain and others, the drones technology and others. So in couple of months, we will be bringing a proper technology so that crime scene management may be proper. Likewise, if you are not well conversed, especially the downline, because forensic experts generally being found, or they generally work in the laboratory, but collection of evidence at scene of crime is very, very, sometimes it is being done by non-professionals many times, especially in developing countries. That way, the developed country has little bit more, but it is not a very rosy picture. All kind of incidents being found there also. That is what I learned from the experts in many other countries, developed countries. Then the degradation. Many times we do not have the storage capacity, proper temperature, climate and all. So your sample may get degraded. There are chances and there are reported cases. I will give you some example. Manipulation and tampering. And that is called forensic fraud. Then at the side of the diagnostic center, that is your forensic laboratory, the accreditation, as I mentioned, the laboratory and the procedure should be properly accredited. Then the metadata, as I mentioned, the hand notes. Let me just talk about the integrity of the sample and the chain of custody. Many a time, the chain of custody from the scene of crime to the laboratory, then from the laboratory to to the expert, and then the making of the report. Here also, there is another chain of custody to be maintained. And if chain of custody is broken by one way or other, or in other words, if the defense lawyer succeeded to prove that chain of custody was broken, whatever good report, whatever convincing report you are making in your sense, it will be zero value in the court of law. So chain of custody is the crucial point at the time, at the stage of from crime scene to your laboratory and within laboratory. So these are the two parameters. These are the two different chain of custody, CODs. Another point is basically coding and decoding. Coding and decoding of samples. Many countries have this a very good system of coding, decoding. But country like India, many other developing countries, they face the challenge. And they generally send the sample with all details of the case references. And another point here, I want to tell you, my dear friends, that all details of the case should not be shared with the expert. Probably you may be knowing about the cognitive bias and confirmatory bias. I think we should understand these biases And the expert on this, Professor ETL, I suggest you that if you can read his work, then you will understand, especially for the forensic science, that how biases get the entire proceeding vitiated. And we all have some kind of bias or other. So how to minimize those bias itself is a challenge, and we should understand. About the forensic fraud, let me give you some example, and there are very renowned examples of 2002 in Massachusetts forensic laboratory, where more than 20,000 cases of narcotics, they were being convicted, but later it was found that by 𝐬𝐤𝐭, the expert of drug, she was actually not conducting any test but producing reports. And when you are producing report without actual conducting the test, this is called dry labbing. Dry labbing. So there are instances of dry labbing everywhere, but how many of us, how many courts actually bother about that, how the reports are being prepared? We are completely unaware. And I am not hesitating in accepting that most of us sitting in any meeting, in any conference, may not be knowing even the term dry labbing. So we have to have a very, very cautious, as a manager, as a senior of the laboratory, that all these things, the fraud should not be done. In India, many cases have been reported. I don't want to tell the name. So what I was telling about the Massachusetts case of 2000, it was actually 2017, sorry. This is 𝐬𝐤𝐭 case. So 20,000 plus cases were of conviction were reversed. The conviction were overturned by single stroke by the authorities there. Likewise, in Houston, in 2000, because of large number of, frauds observed in various branches of the laboratory, the lab was shut down for around 6 to 7 years. I am talking about the Houston crime lab. And I had opportunity to meet and to work there in the last year during my fellowship. And fortunately, last evening, I was talking to the CEO there. He's a good friend of mine. So what I mean to say that forensic frauds are very, very rampant. I will give you one example of India. This is a very critical and very, it will give you some kind of glimpse. This is Khurshid case, the second one if you are seeing. State of NCT Delhi versus Khurshid. I suggest at least to the Indian folk here sitting, at least read this judgment. You will get a fair idea what exactly is this topic what I am referring here. In this case, the child of about 5-6-year-old was raped brutally. The medical legal report, other evidence were cryingly stating that this accused is culprit, the referred accused. But the DNA report was in favor of the accused. That means it was not connecting the crime with criminal. Relying upon the DNA report, bypassing all other evidence, the trial court acquitted that fellow, the accused, Khurshid. This case, as appeal filed by the state, appeared before High Court Delhi. Here there is one important point to mention. The same bench of Honorable High Court Delhi have in the recent past, about in last 2-3 months, they have observed the same type of report by the same DNA expert. That other evidence, all cases were rape with minors, very tender age, 5, 7, 10 years. In all 3 cases, other than Khurshid, the expert have exonerated. The accused was exonerated, and all 3 cases, believing the credence of the DNA report, they were acquitted. Because it was fourth case in the row by the same DNA experts, court gets some doubt. And court requested, or court order, court will not request, they will order. Court order to conduct the DNA test afresh by different experts. And when that report, the fresh report was produced, it was reversed. It was cryingly saying that Khurshid is the culprit. When they sent other 3 cases for retesting, the result was reversed. The accused which were being given clean sheet, they were found connected with the crime. So, my dear friends, such type of incident do happen anyway. We should not we should not be blind. We should not shut our eyes. Every type of people are everywhere. So as a manager who is managing the entire show of the crime lab or forensic science laboratory, whatsoever you call, you have to be very, very honest. Next, please. I think this is the last slide. These are some issues and challenges. If you want to read, you can. Otherwise, next, please. So any question, if you have, please throw it. I will be happy to attend. I think I have taken 45 minutes or 40 minutes. So time is up.